So there are a lot of questions. This is part 3 of my Georgia on My Mind little mini series. There are a lot of questions going on in regards to the loitering or prowling statute. And I hope we can clear some of it up. So the first thing I want to point out is this statute has been around since 1980. One would think if a statute was unconstitutional on its face, and yes, it has been challenged, that any constitutional defects would have either been resolved by now, considering it's been around for 38 years, or the statute would be null and void. But you can see it's not void for vagueness. There's plenty of things in here. Good times. Good stuff. Good stuff. So it's been challenged on being void for vagueness, and we'll take a look at some of that stuff. I've got 3 examples. I thought I had 4 examples. God damn it, why do I keep closing these things? I should have 1, 2, 3, 4. This one. Okay, yeah, we're good. All right. So first stop we're going to take. This is Hansen v. State Court of Appeals. In Hansen v. State, there was a couple guys who were chilling at a parking lot for a apartment complex, I believe. Yeah, it was an apartment complex. He sees a car pointed one way towards the exit. He sees a couple guys next to another car that's pointed in the other direction. It was a white Buick. Ooh, Buicks. I hear they used to be quite nice. What he saw was these young men, or these 2 men, squatting beside a white Buick automobile. He didn't see them breaking into it. He didn't see anything like that. The men got up and walked hurriedly towards the car parked facing the exit. They got in, and they drove off. Well, I'll be damned. The officer pulled aside and let this car pass him. Okay. A short distance further, the 2 men pulled their car over, and the officer passed by them. The officer then went a short distance, pulled over to the side. Eventually, these 2 men passed by him again. What? That's crazy. So, yeah, he ends up pulling him over. They found stuff on him because they could, because they suspected him of 16-11-36. That's the loitering. They had probable cause to pull him over, open up the car, search it. They found Slim Jims in it, etc. Surprisingly enough, they could find them guilty of violating the loitering and prowling crime when no individual thing that they were doing was illegal. Squatting beside a Buick, not illegal. Getting in your car, not illegal. Driving your car, well, there's no evidence they didn't have a valid license or anything like that, not illegal. Pulling over, not illegal. Going further, after you've pulled over, not illegal. I'm hoping you're starting to see a pattern here. Then we have Evans v. State. This one is they see these guys in a parking lot. They're driving a car in a parking lot. Where does it start? Let's see. They were driving a car in a parking lot. Where was it? So, in the instant case, the officer suspected the occupants of Tinch's vehicle were loitering or prowling. Person commits the offense, etc. Where are we at? The officer's suspicion that Tinch and his passengers were in the parking lots in a manner not usual for law-abiding citizens and under circumstances causing concern for the safety of motor vehicle in the lots were not unparticularized hunches, but were based on specific articulable facts. The officers testified that Tinch's car slowly circled the shopping center parking lots for 45 minutes without parking. That's a huge crime. That's a huge crime. I mean, there's laws against that. None of the car's occupants entered a store. The car slowed down and its occupants looked closely at a Volkswagen Cabriolet. Again, excellent cars, or so I've heard. A type of car that is often stolen, and a high number of automobile thefts and break-ins that occurred in the shopping center parking lots. And it was fine. There was no issue with it. It was affirmed. And we got Bellevue State. Now this one is we're going to look at it a little more closely because they actually go into the void for vagueness kind of thing. Boom, boom, boom. All right. So they saw these two guys. They were exiting a property. They were squeezing between the wall and the fence. And the cop said, "Hey, what up?" And they're like, "Oh, dude, we were just taking a shortcut." And did the officer get him for trespassing? No, he didn't get him for trespassing. He got him for loitering or prowling. Now, in this one, they start attacking it on void for vagueness. Let's see. He makes a facial attack, arguing initially it is void for vagueness. The pertinent sections include, etc. You could read them. The defendant here maintains the phrases loiter, prowl, and in a place, at a time, or in a manner are elastic standards which fail to provide sufficient guidelines to ordinary people so they can understand what conduct is prohibited by the statute. In construing the constitutionality of a statute, we must examine it in its entire context. The legislator enacted 1611-36, patterning it after the Florida loitering statute, and Section 250.6 of the Model Penal Code. With the exception of minor distinctions, it is drafted in language identical to that of the Florida statute and Model Penal Code. In upholding the Florida statute against a void for vagueness attack, the Florida Supreme Court concluded the statute could be interpreted in a constitutional manner to prescribe only loitering or prowling which amounts to a threat to the safety of persons or property, conduct which persons of common intelligence may readily appreciate. The comments to Section 250.6 of the Model Penal Code support the interpretation that the conduct sought to be prohibited is only that loitering which creates a danger to persons or property. As a threshold matter, the section requires at least some manifestation of aberrant behavior, and the circumstances must be such that this behavior warrants alarm for the safety of persons or property in the vicinity. We agree with these observations and find them applicable to our analysis of the constitutionality of 1611-36. But see these other ones. While the meanings of certain isolated terms are arguably elusive, the statute, when read as a whole, passes constitutional muster in advising persons of ordinary intelligence of the conduct sought to be prohibited. The statute also defines the offense in terms which discourage arbitrary enforcement. Due process requires no more. The offense of loitering is committed only when the actor engages in conduct not usual for law-abiding individuals, which creates a reasonable alarm or immediate concern for the safety of persons or property in the vicinity. While, as defendants suggest, perspectives may differ as to what conduct is usual for law-abiding citizens, the statute narrows the construction of this phrase by making it clear that the conduct must be that which would alarm a reasonable person. That danger exists to the person or property. The statute further provides guidelines for determining whether this alarm is justified, thus avoiding the possibility of arbitrary enforcement. Initially, the investigating officer must determine whether the suspect's conduct poses a danger to persons or property. Section B offers guidelines to assist the officer in making this determination. However, these guidelines do not require the officer to make an arrest, even if one or more of the situations suggested there is present. If, drawing on all his professional experience, the officer concludes the suspect presents a danger to persons or property in the vicinity and arrests him for loitering or prowling, it is then a matter for the trier of fact to determine whether, under all the circumstances revealed by the evidence, the suspect's conduct gave rise to reasonable alarm for the safety of persons or property. In resolving this issue, the jury may also consider the guidelines of Section B. The statute does not require a conviction if one or more of the listed circumstances is found. We point out that while there are useful guidelines, they do not represent an exhaustive list of factors which may be used in assessing whether the suspect's conduct reasonably warrants alarm. We also point out that under Section B, no violation occurs if the investigating officer fails to afford the suspect an opportunity to dispel otherwise reasonable alarm by explaining his conduct. Following the Florida Supreme Court, we hold that the words "under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity" mean those circumstances where peace and order are threatened or where the safety of persons or property is jeopardized. And then I don't know what this particular ordinance was, but defendant's reliance on this is misplaced. In that case, we struck a municipal ordinance which provided no guidelines by which any citizen who desired to conform his conduct to this provision would be able to discern whether he risked criminal responsibility. As pointed out, it does not suffer from this defect. Now, and then State v. Birch, it just goes over it and it just reaffirms Bell v. State. So, State v. Birch. I don't know if you actually got to see these. This is Bell v. State. Evans v. State. Hansen v. State. So you can see all the citations and everything. If you want to look them up yourself, I'm not trying to play it hide the ball. So from this, what I gather is it doesn't have to be an illegal activity. It just has to make reasonable people think that there may be some potential harm that's going to come of the activity to their persons or property. Now, I know that in the First Amendment auditing community, we all want to believe that a person just randomly filming somewhere is not going to be a danger to persons or property, but that's not how the real world works. People get a little concerned. I was on a phone call outside of my office, which is close to a school, and there were kids around, and a concerned parent came out to see what I was doing. While I wasn't looking at any kids, I was just talking on the phone. So, I mean, in the real world, reasonable people can have suspicions over very minor things. If someone comes into a city hall, for example, filming, refusing to answer basic questions like, why are you filming? What is your name? Do you have any business here besides filming? I'm not entirely sure that a court would find that to be completely unreasonable. I'm in fact of the mindset that a court has a good chance of finding that to be reasonable behavior, a reasonable fear on the part of the people. Now, am I saying that this bearded fella is going to get popped for this? No, I'm not. I'm not entirely sure how far that the city is going to pursue this, although apparently he's been a thorn in their side enough that they've issued criminal trespass warnings. So, that being said, I also don't know how a jury, if he gets in front of a jury, or a judge, if he gets in front of a judge, is going to determine this. So but did they have probable cause? I'm going to say I am 99.9% certain they did. Now, what's his name? Legacy Media guy. He threw up more, and honestly, these are coming faster than I could really follow them. But he threw up Brown v. Texas. So we're gonna round this section out with Brown v. Texas. I withheld it from the first section because I think it fits in better here. Brown v. Texas is obviously a Supreme Court case in Texas. So this particular loitering statute wasn't available in Texas. And he was on the street. He was in an alley. He was in public, in literally like traditional public forum kind of public. It's not owned by anybody. I mean, it's an alley, right? So they couldn't trespass him. But they thought he looked suspicious. And so they stopped him and they demanded his ID. They frisked him and they demanded his ID. And he refused. They arrested him. They took him in. He finally identified himself. It was a minor fine. It was like a $20 fine plus court costs. He appealed it. The court convicted him, and etc. So here's where the flaw comes in, right? So the flaw in the state's case is that none of the circumstances. So they didn't have anything that they didn't suspect him of a particular crime. They suspected him of being suspicious, as opposed to suspecting him of violating the crime of loitering and prowling. I hope you can appreciate the difference. I know it's subtle, but it's a real difference. The flaw in the state's case is that none of the circumstances preceding the officer's detention of appellant justified a reasonable suspicion that he was involved in criminal conduct. They couldn't point to anything and say, we think he's committing this crime. Officer Venegas testified at appellant's trial the situation in the alley looked suspicious, but he was unable to point to any facts supporting that conclusion. There is no indication in the record that it was unusual for people to be in the alley. The fact that appellant was in a neighborhood frequented by drug users standing alone is not a basis for concluding that appellant himself was engaged in criminal conduct. In short, the appellant's activity was no different from the activity of any or of other pedestrians in that neighborhood. When pressed, Officer Venegas acknowledged that the only reason he stopped the appellant was to ascertain his identity. The record suggested an understandable desire to assert a police presence. However, that purpose does not negate Fourth Amendment guarantees. In the absence of any basis for suspecting the appellant of misconduct, committing a crime, the balance between public interest and appellant's right to personal security and privacy tilts in the favor of freedom from police interference. The Texas statute under which appellant was stopped and required to identify himself is designed to advance a weighty social objective in large metropolitan areas, prevention of crime. But even assuming the purpose is served to some degree by stopping and demanding an identification from an individual without any specific basis for believing he's involved in criminal activity, the guarantees of the Fourth Amendment do not allow it. So the difference between Brown is that they thought they could stop anybody and demand ID just because they're suspicious. In this, the person has to be in a place at a time or in a manner not usual for law-abiding individuals, and under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Someone standing in a place where it is unusual for law-abiding citizens to stand filming people, combined with, these are these circumstances, combined with a refusal to identify himself or a refusal to explain his presence, adds up to at least probable cause for violating this statute. I know you don't want to believe it, but I guarantee you there is at least probable cause there. Now, will he be convicted? I don't know. He could be. He legitimately could be. Without violating any rights, he could be convicted. And I know you don't want to hear that, but life is full of things we don't want to hear. And if you start to claim that it doesn't work that way simply because you believe that you don't want it to work that way, then you're just a sovereign citizen. So, again, I'm not trying to suggest that I want Central Civilian Auditor to be convicted of this. I'm just saying that it is a real possibility. It's not invalid or unconstitutional on its face. A good attorney is going to go a long way in preventing him from being convicted of this. So there you go. This is the conclusion of part 3. I believe I have one more section to do. So thanks for watching. Have a good night.